Google's not a good lawyer, okay?
No, it's not, but it ought to have some facts.
It may have something, but you could be very easily misled by what you read, okay?
So what if I refuse to pay? I will never pay her a dime. I will never pay her a dime. This is a fiasco. I do not owe her this money. I never asked to borrow this money, and I will never, ever, ever give her a dime.
Before we start, make sure you subscribe because this case gets wild. A mother drags her own son to court over $10,000, and the question is simple: loan or gift. But once the texts come out, this family...
Okay, the next case we have is Bonnie Carrasco versus Samuel Strader. And y'all had a request to take this off the YouTube? Is that correct?
I did, Your Honor. But
okay.
if it's gonna obstruct procedure, then we can proceed.
No, I just need to know the reason.
The reason is invasion of privacy.
Okay, because Texas courts are considered public.
Okay, well, if anybody wants to obtain public record to these proceedings, they can do so, but they don't need YouTube to do it. Am I wrong?
Well, see, because we're doing it over the video, in a courtroom, we have to have some way to make it public. And so that's what they came up with, was to just put it on YouTube. It's not being recorded.
Yeah, I mean, I guess I understand that, but not really, but that's fine. We can proceed.
Okay. Let's see, Ms. Carrasco, let me, and Mr. Strader, let me swear y'all in. Do each of you swear to tell the whole truth and nothing but the truth?
I do, Your Honor.
Okay, and Mr. Strader as well?
Absolutely.
Okay. Now, Ms. Carrasco, I've been through the evidence that y'all submitted and the petition, and I know this concerns a loan that was made on November 6th of 2023. And the contention you're making is that it was a loan?
Yes.
And you've been trying to collect on that loan?
Yes.
When was the first time that you, if you can recall, as I said, that loan was in November of 23. When was the first time that you made an effort to try to collect on that or talk to your son about collection on that?
In February.
In February of 24? Okay.
Yes.
And
also, Your Honor, I'd like to point out that any reference to my medical condition should be stricken from the record. He had no business admitting it. He is not a trained psychologist.
Right. That's not relevant. It's not
correct.
Relevant. So that was in February.
Yes.
And what other efforts did you make besides the
well, I can tell you this: 2 days after we filed the court almost a year ago, he came into my house intoxicated with George Ferguson and said, "Meet me at the bank." 2 days after he was served.
After he was served? Okay, because
yes.
This was filed on March 21st of 24.
Yeah,
so
he came in, and once the constable served him, he arrived at my house, said, "Meet me at the bank," said an F word to George Ferguson, and said, "Meet me at the bank tomorrow." You sent the police to my house. The day after he was served.
The day, okay, and what happened then?
I said, "I don't need to go to the bank. You're intoxicated." You said, "F you to George." There's evidence said we can have a civilized conversation. I said, "Go in my bank," because he banks, Your Honor, where I bank, and deposit the money or make a payment plan. I also, on July 10th, Your Honor, I know there's a lot of evidence, I offered him a settlement.
I read that.
Of $150 to $100 a week. He works for the city of Austin, making $62,000 a year plus, and took another $10,000 loan that he showed me on his phone to use as, quote, a cushion, Your Honor.
Mhm.
cushion.
His own business. He didn't accept the settlement. That, I know that
Correct.
happened.
Correct.
But,
Now, if you look at Sunday, February 18th,
mhm,
I need $250 by the 1st. I'm fat effing broke. I apologize for my language in advance.
mhm.
You agreed to make a payment plan, and I haven't seen your payment. So what is your plan? You also have Aaron or Paula call me at the bank, because he banks where I bank, Your Honor.
Mhm.
By the way, this is Sammy. This is business. He says this is extortion. This is him talking to his own mother.
Is that filed in the exhibits that you sent?
Yes.
Which one is that in?
By the way, this is extortion. It's February 18th to Saturday, March 23rd at 4:16 p.m.
Well, it's first you sent in that plaintiff's exhibit packet, and then you sent in plaintiff's account history and loan and security agreement. And
Right.
that bunch of evidence. Do you know where it is?
What do you mean?
What you're quoting from, the extortion statement. In which of those exhibits is it in?
It is dated Saturday, March 23rd at 4:16.
I just don't.
It's a text message.
Right. I'm just not, I don't remember reading that part.
I can show it to you. It's right here, Your Honor.
Pardon me?
Can you see it?
Oh, okay. Okay. See, I just don't remember. Okay. Go
Okay,
ahead.
so hold on.
Mm-hmm.
Can you see where it says this is extortion?
Mm-hmm. Yeah. Okay. And that was February 18th?
March 23rd.
Oh, that was March 23rd. Okay. Go
Yep.
ahead.
This exhibit, Your Honor. Can you see it, Your Honor?
Mm-hmm. Yeah. Go ahead.
Can you see what he's saying?
Yes. Now that one I saw.
Can you read that to the court, please? And on the record?
Oh, it's in there. It's in the.
I'm going to nominate you for Mother of the Year. No arrest in 13 years. Wow, it's really amazing how much you want to help your mom, who gave you 10 grand. Let me emphasize the word gave, Your Honor, with all due respect. The bank gave me a loan. Gave does not constitute, the word gave in legal terms does not constitute gift.
Right. Okay. Go ahead.
So, will you accept half or not? Do you see that, Your Honor?
Uh-huh.
If it's not a loan, why is he accepting half?
Mm-hmm. Mm-hmm.
Because the burden is on me, or the burden is on him to disprove this.
Wait, did you catch that? The son literally offered to pay half the money back in a text. And in court, that can look a lot like admitting it was a loan.
See this text message, Your Honor?
Yes. Yes.
That's coercion. No arrest in 13 years. He did a background check on his own mother when he's a convicted felon.
Well, we're just talking about the nature of the loan right now.
Correct. You see this, Your Honor? He banks where I bank. I called my bank. They said, you don't need to go into the bank with Sammy because frankly, he scares me.
Mm-hmm.
I don't even want to see his face during this. I'm a nervous wreck.
Mm-hmm. Okay.
I said, yeah, Paula or Aaron call me because he banks where I bank. And you don't even need to be here. We'll put the money in the bank. He did not.
Okay.
And P.S.
Okay.
Ask him why he borrowed 10 grand. Ask him how much he spent on his wedding. Because I know.
Well, we're
And
just,
I believe, Your Honor, with all due respect, this should now become a community debt should I win the case.
no, it's what it was at the time of the making.
Okay, you see this exhibit, Your Honor?
Mm-hmm.
I'm willing to do this out of the goodness of my heart.
Mm-hmm.
Really? Really?
Okay.
Another admission. You see this exhibit, I told you, pay house, buy house, give back, or pay bills. Now, if defendant offered me 10 grand, Your Honor, I apologize for shouting. You see how bad I'm shaking.
Mm-hmm.
Why would I say, oh no, Sammy, I don't want your 10 grand?
Mm-hmm.
That's an outright lie.
Mm-hmm. Okay.
And you have no case. This is his arrogance.
Mm-hmm.
And we're just about done here. You see this exhibit? I'm willing to have a civilized conversation about this without your bodyguard. That was George. When he walked in and said, fuck you to George.
Mm-hmm.
You see this? You are psycho narcissistic. Read that, Your Honor. With all due respect. You're going to talk this way to your mother who let you live here and walk out of my house with $15,000.
Okay, we're just going to talk about the loan. We're not going to talk about the tenor of his other statements, just the loan.
Again, Your Honor, at the bottom, I am willing to pay half.
Mm-hmm. Mm-hmm.
Again, Your Honor, show his arrogance. Your first mistake is thinking you can tell me what to do. Do you see it?
See, that's what I don't want to hear stuff like that right now. I just want to hear about the nature of the loan.
Okay. Well, I think I've submitted enough evidence. Do you have any questions for me, Your Honor?
No, not at this time.
Thank you.
But you are requesting return of the $10,000. That's what you're asking.
I'm willing to settle the case right now today for $5,000.
If he wants to do that for $5,000?
Yep, that's giving him half. Oh, one more thing.
Mm-hmm.
That he's taunting me. Free legal advice is nice. Who does that to their own mother, Your Honor? I know it's irrelevant, but not to me. You realize what that's done to me? Look, I'm shaking.
Okay, try to relax. Okay, just try to relax. Mr. Schrader, she says she'll settle for $5,000 right now.
Yeah, I hear her.
Cash again.
Is she going to unmute or is she going to mute?
Yeah, let's talk to Mr. Schrader right now, Ms. Carrasco.
Sure.
Go ahead, Mr. Schrader.
I'd be happy to answer any direct questions, but my testimony has not changed.
Well,
this was never a loan. I mean, if you want some background, I can give it to you.
Well, first I want to know if you accept the offer.
No.
$5,000. Okay. Okay, go ahead.
Do you have any questions, direct questions for me, or do you just want me to do what she just did and tell you the whole story?
I just want to know the presumption in law is that it is a loan. You need to establish it was a gift. That's the legal.
I mean, how has this been proven a loan thus far?
because she is indicated that it's a loan. She says it was a
Okay.
loan.
Okay, but it's my word against hers, right?
Well, that's what I'm saying. The legal presumption is that it is not a gift. And you need to tell me how it is a gift.
Okay, because she told me to keep it on the phone, which is on record with Consumer Cellular, which unfortunately you can't subpoena phone calls because this is not Law and Order. This is not TV.
Right.
However, that's how it went down. $10,000 to a guy like me is life-changing money. And she also left out the part where she had a house picked out on Oak Alley right around the corner from her house for $450,000. And I quickly assessed the situation and said, there's no way possible that you can buy a house in Austin, Texas for $450,000 with $10,000 down. So I said, we're not buying a house. I'm 53 years old. I'm not hitching myself to a mortgage. And it's impossible to do with only $10,000. So I can either pay off some bills with this or I can give it back. She said, keep it. It's a gift. She was happy. She was living her life. She was doing her thing. She was spending money all over the place. And I was happy for her. I was like, well, maybe it'll stick. And it didn't. So, if you read the evidence that I submitted, the letter that I wrote to the court, it's almost verbatim. You don't have to remember anything when you're not lying. This is actually what happened. And then right after that, she said, don't tell Ben. Ben is my brother. He's a very successful family court lawyer. Mm-hmm. And she said, don't tell him. And I said, well, that's no problem. We never talk. Mm-hmm. What does she do 2 weeks later? She tells Ben. Ben goes ballistic because he's entitled, he's selfish, and he's greedy. He says, where's my 10 grand? And if he was here today, if he was sworn to tell the truth, the whole truth, and nothing but the truth, he would admit to that statement. Now, why would he make that statement? Why would he say, where's my 10 grand? Well, if it was a loan, why would he say, where's my 10 grand?
We're getting into hearsay here. So let's just talk about the things that we know about.
This whole case is hearsay, Your Honor. This whole case is hearsay.
No, statements that the parties make are not hearsay.
Is there a contract with my signature on it, agreeing to terms of a loan or to agreeing to making payment?
Now the son says the money was a gift, not a loan. But without proof, it's basically his word against his mother. And those earlier messages might come back to haunt him.
The only reason I agreed to half is because I thought she had borrowed that money to give to me. But no, she didn't. It was cash money. Now, if she'd come to me in the beginning and said, look, I made a mistake. I don't have $80,000 at the end of the year like I told you. I need that money back. Can you help me out? Yeah, no problem. I got your back. But she started threatening and wanting to sue. And all this came right on the coattails of telling my brother, which she told me not to do. She wants to please him. This whole thing is about him. As soon as she told him and he got upset, then it became a loan. All of a sudden, it's a loan. Oh, I want the money. I told Ben you were going to pay me back. I said, why did you tell him that? I'm not paying you. That money's gone. I used it to pay off some things and to put a little cushion in the bank for myself and to be comfortable. Like I said, $10,000, Your Honor, is life-changing money to blue-collar workers, to guys like me. This thing is all about her winning. She wants to win. That's all it's about. It's not about the money. She's not broke. She doesn't need it. She's retired. She's bored. She's depressed. I'm not going to get into any more of that, but I'm shaking too. You just can't see it.
Mm-hmm. Okay. Anything else?
No, ma'am.
All right. Ms. Carrasco, you're the plaintiff, so you get the last word.
Ben's testimony is hearsay, Your Honor. there's no proof of that.
It's not hearsay, ma'am, because he's a party.
Excuse me?
It's not hearsay because he's a party. You guys are using legal words you don't know the meaning of.
Oh, okay.
Yeah, nothing.
Well, you saw the evidence. He agreed to pay it back or give it back, and he borrowed 10 grand, and he makes $62,000 a year at the city of Austin.
I never borrowed anything from you. Admit the truth.
Mr. Strader, this is her turn to talk.
You lived with me, Sammy, for a year and walked out of here with 15 grand. I never charged you.
Ms. Carrasco, you address your words to the court.
Okay. He lived here, Your Honor, and walked out with 15,000. I never charged him. I helped him get a job. I helped him open a bank account at UFC where I bank. I helped him buy a car.
Mm-hmm. Okay.
I begged Mr. B to give him a job at Circle K where he could save all his money. Can he hear me?
Mm-hmm. Mm-hmm.
He immediately started drinking, smoking weed, spending all his money 2 months after getting out of prison. So I can't control that.
Mm-hmm. Right. Okay. All right.
And I would like to apologize to the court for the vulgarity, but this is a highly volatile case, and I don't want Sammy anywhere on my property in the future.
No, that's okay. We have certainly understand that's okay. People get emotional. All right. Well, based on the evidence presented, I find that the plaintiff has established a cause of action for $10,000. I will enter a judgment on her behalf for $10,000 plus court cost. Each party does have at least 15 days to file a motion for new trial and 22 days to appeal. Any
Your
questions
Honor,
about?
Your Honor, can I ask a simple question?
No.
Where is the evidence that this was ever? Where is my signature on anything? Where is there a payment
Mr.
plan?
Strader,
Where? How has this been proven?
if you want to appeal, please feel
I will
free.
be appealing. I promise you that.
Excellent.
Your Honor, I have
We will
one
have
question.
a copy of the judgment out at the conclusion of this hearing, and the appeal bond is set at $20,000.
What is an appeal bond?
And if you need an indigency affidavit because you cannot afford the appeal bond, that will be provided as well.
What
You can
is an
visit.
appeal bond?
That's what you put up for the appeal so that you
I
can.
mean, I don't understand. What do you mean? What I put up for the appeal? Am I going to jail?
No, you can visit with the civil clerks if you have questions about the procedures. Thank you very much to both parties for appearing today.
Your Honor, I just have one last. I have one last question. Since I've won this judgment, I'm entitled to a writ of garnishment, correct?
Not until it's final. It's not final yet because he has to appeal it.
Right.
Your Honor, I thought the only thing in the state of Texas that could be garnished was child support and taxes.
That's not true. You guys really need to talk to lawyers about this stuff, okay? You really do. I cannot give you legal advice because I'm.
It's on Google.
Well,
it's on.
Google's not a good lawyer, okay?
No, it's not, but it ought to have some facts.
It may have something, but you could be very easily misled by what you read. Okay.
So what if I refuse to pay? I will never pay her a dime. I will never pay her a dime. This is a fiasco. I do not owe her this money. I never asked to borrow this money, and I will never, ever give her a dime.
Thank you for appearing today, and I hope you have a pleasant afternoon.
And the judge makes it official. The son must pay back the full $10,000. No written contract, but the messages convinced the court it was a loan. If this case shocked you, like the video, comment your opinion, and subscribe for more crazy courtroom breakdowns.